In conference rooms across Silicon Valley, tech companies are facing an uncomfortable question: what happened to the voice recordings you shared with Siri, Alexa, and Google Assistant? Court documents filed in federal court allege that some of the world's largest technology companies collected millions of voice samples from users, then used those recordings to train artificial intelligence systems without obtaining proper consent. The lawsuits, which span multiple states and involve billions of dollars in potential damages, claim these companies violated one of America's strictest privacy laws. This is the story of how your voice became evidence in a legal battle over the future of AI. According to legal filings reviewed for this investigation, the defendants include Google, Apple, Amazon, and Meta. Each company operates voice-activated systems: Google Assistant, Apple's Siri, Amazon's Alexa, and Meta's voice features across Facebook and Instagram. The lawsuits allege these companies collected voice recordings when users interacted with their devices and services. Court documents claim the recordings were then transcribed by human reviewers and used to improve AI models. The companies have not denied collecting voice data, but dispute the legal claims against them. Together, these tech giants represent trillions in market capitalization and billions of users worldwide. To understand the allegations, we need to examine how voice data collection operates. When a user activates a voice assistant by saying a wake word like "Hey Siri" or "Alexa," the device begins recording. According to court filings, these recordings are uploaded to company servers for processing. The companies acknowledge this basic process in their privacy policies. What the lawsuits challenge is what happened next. Plaintiffs allege that human contractors listened to these recordings to verify accuracy and improve the AI. Court documents cite reports from news outlets including The Guardian and Bloomberg that exposed these human review programs at multiple tech companies. In 2019, media investigations revealed the scope of human review programs. According to court filings referencing these reports, contractors for Apple heard confidential medical discussions, drug deals, and intimate moments. Google reviewers allegedly listened to recordings from its home devices and Assistant. Amazon employees reportedly transcribed thousands of Alexa recordings daily. Bloomberg and The Guardian published accounts from contractors who described listening to recordings that users likely never intended to share. The companies, according to the lawsuits, did not adequately disclose that humans would review these recordings. These revelations form the factual basis for many of the legal claims now advancing through federal court. The lawsuits center on a statute most Americans have never heard of, the Illinois Biometric Information Privacy Act, known as BIPA. Enacted in 2008, BIPA regulates the collection of biometric identifiers, which the law defines to include voice prints. According to the statute, companies must obtain written consent before collecting biometric data, must publish retention policies, and cannot sell or profit from biometric information. Legal experts note that BIPA is unusual because it allows private citizens to sue for violations, even without proving actual harm. The law carries statutory damages: $1,000 per negligent violation, $5,000 for each intentional or reckless violation. With millions of potential violations alleged, the damages could reach billions. The legal battle hinges on a technical question: does voice data constitute a voice print under Illinois law? According to court filings, plaintiffs argue that when companies use voice recordings to train AI recognition systems, they create biometric identifiers unique to each speaker. These identifiers, they claim, are voice prints. The technology analyzes characteristics like pitch, tone, cadence, and accent to identify individuals. Experts cited in court documents explain that modern AI systems can distinguish one person's voice from millions of others with high accuracy. Defense attorneys counter that merely recording a voice is not the same as creating a biometric identifier. This distinction will likely determine the outcome of the cases. Google has moved to dismiss the claims, according to court records. The company's legal briefs argue that voice recordings are not biometric identifiers under BIPA. Google contends that the law targets identifiers derived from physical characteristics, not recordings themselves. Additionally, Google argues that users consented to data collection through terms of service agreements and privacy policies. The company's attorneys note that Google Assistant's setup process includes disclosures about data use. Court filings also show Google arguing that many plaintiffs lack standing because they cannot demonstrate they were specifically harmed. The judge has yet to rule on these dismissal motions, and the arguments reveal how tech companies interpret user consent in the age of AI. Apple has filed similar defenses, court documents show. The company argues it does not create voice prints from Siri recordings, merely processes audio for speech recognition. According to legal briefs, Apple maintains that its privacy practices exceed industry standards. The company notes that it allows users to opt out of data sharing and has implemented encryption for voice data. Apple's attorneys also challenge whether Illinois law can apply to users outside Illinois who interacted with devices manufactured in California and processed on servers in multiple states. This jurisdictional argument could limit BPA's reach. However, plaintiffs counter that Apple's privacy changes came only after media exposure and that prior practices violated the law regardless of subsequent reforms. Amazon faces allegations specific to its Echo devices and Alexa voice assistant. Court filings claim Amazon retained voice recordings indefinitely and used them to train AI without proper disclosure. Amazon's defense, according to legal documents, emphasizes that users can delete recordings and that Alexa's functionality depends on cloud processing. The company argues that BPA does not apply because voice recordings are not biometric identifiers. Amazon also contends that users in Illinois represent a small fraction of its customer base and that most interactions occurred outside the statute's jurisdiction. Plaintiffs respond by citing internal Amazon documents, reportedly obtained through discovery, showing the company new recordings captured sensitive conversations but continued collection practices unchanged. Meta's involvement centers on voice features in Facebook and Instagram, according to court filings. The lawsuits allege Meta collected voice data through video uploads, voice messages, and other features, then used audio to train AI for content moderation and advertising. Meta's legal response argues that social media voice features differ fundamentally from dedicated voice assistants. The company contends users voluntarily uploaded voice content, distinguishing it from passive collection by always listening devices. Court documents show Meta also arguing that it never created voice prints as defined by BPA. However, plaintiffs cite Meta's own patent applications for voice recognition technology as evidence the company did develop biometric voice identification capabilities, contradicting its legal claims. These cases are proceeding as class actions, meaning a few named plaintiffs represent millions of potential class members. According to court filings, the proposed classes include anyone in Illinois who used the defendant's voice features during the statutory period. Attorneys for the plaintiffs estimate class sizes in the millions for each defendant. Court records show judges have not yet certified the classes, a critical step that defendants are vigorously opposing. If classes are certified and plaintiffs prevail, damages would be calculated by multiplying statutory penalties by the number of violations. With millions of users and potentially multiple violations per user, legal analysts following the cases note the damages could exceed the gross domestic product of some nations. Central to every defense is the question of consent. Tech companies argue their terms of service and privacy policies constitute written consent under BPA. Court filings include exhibits showing privacy disclosures from each defendant. However, plaintiffs argue these policies fail BPA's requirements. The law demands informed written consent specifically for biometric collection, not general data use agreements. Legal experts cited in court documents note that BPA's consent standard is higher than typical privacy laws. Plaintiffs also argue that many users never read terms of service and that burying biometric disclosures in lengthy legal documents does not constitute meaningful consent. This debate reflects a broader tension between tech industry practices and evolving privacy expectations. The lawsuits expose how AI systems learn from human data. According to court documents and technical experts, voice assistants improve through machine learning, which requires vast datasets of human speech. Engineers feed recordings into neural networks that learn to recognize patterns, accents, and context. Court filings allege companies used recordings without compensation or consent to build proprietary AI models worth billions. This raises questions beyond privacy. Who owns the value created when human data trains commercial AI? Legal scholars note BIPA does not address AI training specifically, as the law predates modern machine learning. The cases may establish precedents for whether AI development constitutes profiting from biometric data under the statute. Legal experts interviewed for this investigation outline several possible outcomes. First, judges could dismiss the cases if they agree voice recordings are not biometric identifiers under BIPA. Second, courts could rule tech companies obtained sufficient consent through existing policies. Third, cases could proceed to trial, where juries would decide if violations occurred and calculate damages. Fourth, and perhaps most likely according to attorneys following the litigation, parties could reach settlements. Court records show preliminary settlement discussions have occurred in some cases. Settlements could involve monetary payments to class members and, significantly, changes to how companies collect and use voice data. Any outcome will influence how tech companies develop AI and handle biometric information. BIPA is unique to Illinois, but the lawsuit's impact extends nationally. Other states have considered similar biometric privacy laws, and these cases provide a test of how such regulations affect the tech industry. According to legal filings, defendants argue that allowing Illinois law to govern their nationwide operations creates unworkable compliance burdens. Plaintiffs counter that companies can easily comply by obtaining proper consent or not collecting biometric data. The litigation has already influenced corporate behavior. Court documents show all defendants modified their voice data practices after the lawsuits were filed. Privacy advocates cite these changes as evidence the legal pressure works, while tech industry groups warn that aggressive litigation could stifle innovation in AI and voice technology. For individuals concerned about voice data collection, court filings and privacy experts offer several recommendations. Users can review and delete voice recordings through account settings on most platforms. They can disable voice features or opt out of data sharing where possible. Court documents note that all defendants now offer more transparency about voice data use than they did when these lawsuits began. However, experts caution that opting out may limit device functionality. Users in Illinois may have legal recourse under BIPA if they believe their rights were violated. Privacy advocates recommend reading updated privacy policies, using privacy settings actively, and supporting legislation that extends protections beyond Illinois. The lawsuits have created awareness, but individual action remains necessary. These lawsuits represent a pivotal moment in the collision between AI development and privacy rights. As artificial intelligence becomes more sophisticated, it demands ever larger datasets, much of it collected from ordinary people during everyday activities. The voice data cases force courts to answer whether existing privacy laws can govern technologies their authors never imagined. Legal scholars note that BIPA, written in 2008, now regulates machine learning systems that didn't exist when the law passed. The outcomes will signal whether companies must obtain explicit consent before using personal data to train AI, or whether general terms of service suffice. For the tech industry and millions of voice assistant users, the answer will reshape how we interact with the devices that increasingly surround us. The litigation continues through federal courts with no final resolution in sight. According to court dockets, motions to dismiss remain pending in several cases, while others have advanced to discovery, where plaintiffs obtain internal company documents. Attorneys on both sides told reporters they expect the cases to take years to resolve fully. Class certification hearings are scheduled in multiple jurisdictions. Settlement talks have occurred but produced no agreements to date. Meanwhile, the companies continue operating their voice services under modified privacy policies. Whatever the eventual outcome, these lawsuits have already achieved one result: they have forced tech giants to confront the consequences of collecting voices from millions of users to build the AI systems that may define our technological future. The final chapter remains unwritten.